Hi, everyone, and Happy New Year. Welcome to our first webinar of the year, which is on the FATF's updated guidance for a risk-based approach to virtual assets and virtual asset service providers. I'm Whitney Morgan, the head of partnerships at CoinFirm. We're a leading blockchain analytics and investigations company used by exchanges, banks, governments, and other companies all over the world to help analyze and manage their risk. I'm going to moderate our panel, but to start, I'd like to introduce the expert panelists that we are lucky to have here with us today. So we're grateful to have Harriet Terrett, who is a partner at Jones Day in the UK. Harriet has over 20 years of experience resolving significant financial disputes and regulatory issues with a focus on innovative financial technology like DLT. Harriet is regularly asked to advise on complex issues related to global financial sanctions and money laundering rules, and to represent organizations and individuals in enforcement proceedings before regulators like the FCA. And then next, we have Harriet's colleague from the other side of the pond, Josh Sterling, who has spent over 20 years in the derivatives and securities markets as both lead counsel to large companies and also as a senior federal financial regulator himself. Josh frequently represents clients in the industry with matters before the CFTC, the SEC, and various self-regulatory organizations. He has also helped drive the CFTC's innovation initiative in the crypto asset space. And then last but not least, we have my colleague, Barbara Halasek, who is the head of regulatory affairs here at CoinFirm, and she's responsible for regulatory compliance across all of our products. She has extensive experience in a variety of AML and compliance matters, having served in a number of senior compliance roles at global banks, including both UBS and Deutsche Bank. And then unfortunately, Ethan Hack can't be here with us today, so we'll catch him another time, but welcome to all the panelists and thank you for joining us. So, thank you. So before we dive into the meat of the discussion, I know we have hundreds of attendees on the webinar who are coming from a range of both industries and also experiences with digital assets. So I want to share just a quick intro on the FATF so everyone has some baseline context as to what we're talking about today. So the Financial Action Task Force is a global money laundering and terrorist financing watchdog that sets standards that promote the effective implementation of legal, regulatory, and operational measures that help maintain the integrity of the international financial system. They were founded in the late 80s and have more than 200 countries and organizations committed to implementing the standards, so very wide-reaching. And in 2019, they put out their original guidance regarding virtual assets to help countries and VASPs both understand their AML-CTF obligations and also implement the recommendations. And then that's been iterated on over the years. And the latest update to the guidance was published in Q4 of last year, which covers 6 key areas, a few of which we'll dive into. So in a tiny, tiny nutshell, that's the FATF and also our starting point for today's discussion. And finally, just some housekeeping before we turn to our panelists. I want to remind you, we have a good chunk of time for Q&A towards the end, but you can submit your questions, like anything that comes to mind throughout the entire discussion. Just click on the Q&A button at the bottom of the screen. Okay, so let's turn to the panelists. And I want to start with the first of the 6 key areas, which is FATF's definitions for virtual assets and virtual asset service providers. So for VAs, what is under scope now? Do you all agree with the new definition?
Well, thanks, Whitney, for that very much. And it's a pleasure to be here with you, Barbara, and always, of course, Harriet today, and with the many folks participating around the world. So very happy to kick it off here at an extremely high level. The FATF guidance that's relevant does contain a definition of virtual asset, and I read it to be precise. It is a digital representation of value that can be digitally traded or transferred and can be used for payment or investment purposes. Now, that doesn't include digital representations of fiat currencies, securities, and other financial assets that are otherwise covered by the FATF recommendations. So the definition itself is incredibly broad. You know, a digital representation of value that can be digitally traded, transferred, or can be used for payment or investment purposes. In my travels in the digital asset space, that covers just about anything that can be represented by a token or otherwise represented with a unique identifier on a blockchain. So I think that it is incredibly broad, and if the point of the guidance is to capture any sort of digital financial activity at all, I think this definition certainly is broad enough to capture it, and then that relates to what we'll talk about in a moment, which is how one defines VASP, a separate but importantly related term. I would refer to other panelists as to whether there's room to agree or disagree on the breadth and depth of the definition.
I mean, look, unsurprisingly, I completely agree. I think I would kind of make just a couple of points, which is the process that we're seeing come out from FATF is not unusual for global standards or frankly for national standards. Whenever a new business model, product or service comes within scope of financial regulation, it is comparatively rare to go from kind of 0 to 100 in one go, because everyone recognizes the kind of uplift that that puts on the new industry. And generally, and I would include crypto in this, these are industries that most countries and financial regulators want to encourage, but obviously are trying to do on a risk-based basis. So in some ways, it's not at all a surprise to me that we started with a slightly smaller, less expansive, perhaps less controversial definition. And we can sort of come on and talk about the definition of VASP, because that's where I really do see it's kind of gone from a fairly defined group to actually a much broader group. So I think the process is not unusual. It's not that surprising. There is quite a discussion about whether it's an expansion or a clarification. I'm conscious we've got a lot of people on here, and I'm very grateful that none of you left when you heard you were going to be addressed by basically 3 regulatory and compliance leaders. But that I think FATF would say, actually, this is just clarifying the scope of what's already there. I would be more realistic. I would say in any kind of situation like this, where you have new regulation coming into a nascent, growing and dynamic business, I kind of describe it as unstoppable force, immovable object. But I guess it's also like water flows around rules. So whenever you have a rule, people will find ways to develop the technology to possibly take themselves outside of scope of the rule. And I think what we're seeing here is FATF saying, actually, there isn't a way in which you can structure around these rules. And again, we'll come on and talk about DeFi. I think some of the most interesting commentary in the guidance is around DeFi, which definitely FATF and national governments see as a challenge to existing, normalized in the context of the financial industry, rules about how you deal with particularly things like money laundering. So it's super interesting if you're geeky like me, but I think it's also setting down a marker that the crypto industry does fall within scope, regardless of how the technology is being used.
I would certainly agree with that, and with broadness of the definition. I think there's even a paragraph or a sentence in the guidance which states that if an asset, that it is unlikely for an asset not to be covered either by standard definitions of financial instrument or virtual assets. So basically what FATF is trying to say is that if you're looking at an asset, it is covered as an asset either way, either financial instrument or virtual asset. So certainly the broadness of the definition is increased. And interesting point you might heard about the expansion versus clarification. I think that the language kept repeating in the guidance, it is really a clarification. But really from talking to our customers, from seeing the reactions from the industry, it is clear that those boundaries of the definitions were not clearly understood, or were not, let's say, read in the same way as FATF might have intended, but perhaps was not well, sufficiently detailed on that point. So it's great to see that level of detail. What I would add from the private sector perspective, though, is it's great to have the detail. It's great to have the broad definitions there. I totally agree with that. However, I think over the time, we will see more and more case-by-case challenges as to how to apply those definitions. And what I would certainly welcome from the private sector side is that private and public sector work together towards developing some sort of case studies, some sort of more detailed guidances in especially those edge cases where, say, for example, with NFTs, when do we say that, well, FATF states that it's a virtual asset if it's used for investment purposes. When is it used for investment purposes? When it is not? I do hope that sometimes we will get more of a detailed guidance with case studies.
So it seems like the process and how things are unraveling is not necessarily surprising or unexpected, but it's certainly a big scope. And so then let's move over to VASPs, since we touched on that already. So what does the guidance say about defining the VASPs and who's covered?
Sure, and happy to sort of kick off going around the circle again on this one, Whitney. So again, reading from the guidance here, in the glossary, virtual asset service provider, or VASP, means any natural or legal person who is not covered elsewhere in the recommendations. That's pretty broad. And a business that conducts one or more of the following activities for or on behalf of another natural or legal person. So a type of intermediary or facilitator. And those activities are as follows. There's 5 of them. One is exchange between virtual assets and fiat currencies. The second is exchange between one or more forms of virtual assets. The third is transfer of virtual assets. Fourth being safekeeping or administration of virtual assets or instruments enabling control over virtual assets. And finally, participation in and provision of financial services related to an issuer's offer and or sale of a virtual asset. So again, an incredibly broad definition, I think, that is meant to look at digital finance from the traditional finance framework and capture every core functionality involved within an ecosystem of payments or investment. That's how I would have read it when I was in government at the CFTC, and we can talk about this later, but I had some experience in helping charge a digital asset company with money laundering violations. So I do think it's incredibly broad. But over to Harriet.
Yeah, I mean, I've got to be honest, I don't have much to add to that. I mean, I do think it follows the same trajectory of a comparatively narrow definition that was talked about kind of 2 or 3 years ago, that it has now been expanded as the industry, frankly, has got more mature. And like, for those of you who are in the crypto industry, I know it can be difficult to see anything positive in this, but this really is a sign of the maturity, the sophistication, and frankly, the size and impact of the industry. So FATF and national governments would not be doing this if there weren't kind of concerns about the risk-based approach. I appreciate that's cold comfort if you are the one at the sharp end dealing with it, but I do think it's following a comparatively kind of normal trajectory for me in terms of kind of regulation. I do think that it's good to see, again, some of the kind of key issues or discussions. I think Barbara made this point really well, which is we've actually got some clear guidance. For once, we've got some clear guidance about how these things are supposed to apply to different situations. And no, it doesn't cover absolutely every situation, but it definitely seeks to address some of the more common questions. So, one of the kind of very early discussions was, should crypto to crypto asset service providers be included, or should it only be fiat to crypto who are within scope, because money laundering technically involves sort of movement of money within the fiat money context. And that's obviously now been resolved not only by the definition but by the guidance. Yes, it has brought a lot more people in scope, but I think it has, at least for me when I'm advising clients, it has clarified the advice that I can give to clients, and frankly given them more certainty about when they're within scope and when they're not, even if their home jurisdiction has not themselves given that kind of definition. So that, again, we'll come on to talk about this. Some of the early jurisdictions that have implemented effectively the FATF guidance through their existing regime, but there isn't a lot of specific guidance about how it applies in different situations. The FATF guidance, I think, is quite helpful for that, if you assume that the manner of implementation by those companies is intended to meet the FATF requirements, countries, I should say.
Thanks for that, Harriet and Josh. I think from my perspective, I would agree to a certain extent that the definition is broad. The reason I'm saying that is comparing that with crypto asset service provider definition from markets in crypto assets directive in Europe. That definition actually doesn't seem that broad. I mean, it is broad if you look at that in isolation, but then when you compare it what Mika is introducing, which is even broader, and a little bit from looking at the activities from a little bit different angle, I sort of turn back to FATF and say, well, actually that definition is not that bad. So that's obviously a separate topic, a completely separate piece of guidance, but just wanted to point it out there that it is fairly structured in comparison to what I'm seeing in Mika, which is supposed to come in Europe within the next few years.
And actually, I think that's a really good point. And I think there is a risk of kind of unintended consequences. So I appreciate we're not going to talk about MiCA here, but there are something like kind of, I think it's last count, 265 separate proposed amendments to that. But when you dig into them, actually quite a lot are talking about the unintended consequences of having such a broad definition and such a broad regulation in a space that is already, in many respects, quite heavily regulated. And I think one of the good things, as Barbara says about the FATF guidance, is there are some potentially unintended consequences, but there's not that same effectively clash between regimes.
Yeah. One more thing that I would add on that, so is with regards to the application of that definition into DeFi, I must admit that Confirm here was sort of a future teller in that sense, that we've always believed since DeFi emerged that sooner or later it will be caught in the definitions. And this is why since the very beginning we've worked hard on providing the markets with the ready-made solutions for DeFi compliance, for looking at DeFi platforms and assessing their risks, or providing them with tools to control the risks. And so that's the development that was certainly foreseen and not surprising. That is not to say that there are no challenges. Of course, there are challenges with regards to application of that definition, for example, to DAOs. And I think a lot of conversations will still have to take place, again, hopefully between public and private sector to come to a conclusion how to practically get that definition applied.
Thank you. And just to wrap up this section on the definitions of virtual assets and virtual asset service providers, are there any other key challenges that you all think that we haven't addressed yet that people need to think through at this stage?
I mean, I appreciate we're going to get to the Q&A, but I can see someone's put kind of one interesting issue out there, which is some of the more technical stuff. So providers of unhosted wallets, are they within or without the guidance? And there's actually, as I think probably those people will have seen, there's some very specific discussion in the FATF guidance around some of those specific cases. And that's probably one area where the guidance is not particularly clear. I mean, unhosted wallets themselves do not come within scope at the moment. There's an interesting question as to whether a provider of those wallets does it fall within the broad definitions? And I think there are certainly some regulators who take the view that it does and it should. And I think it's worth remembering here that FATF is a global standard, right? So no one takes FATF and it doesn't apply directly. Individual countries then have to bring the FATF standard within their existing money laundering regulation. And we are seeing lots of variation already on particular issues, some of which we're going to come on and talk about. So I think the answer to that question is, as a sort of a discussion, is it very much depends on the country that you're in and whether you're within scope of business, but there is definitely potential for a provider of unhosted wallets to come within scope. The wallets themselves, I think the guidance already says will at this point and probably for future fall outside scope.
Thank you. And the third area of the updated guidance addresses P2P transactions. So noting that they may pose a greater risk given there are no obliged entities involved. So what does the updated guidance tell us about P2P transactions? How can we best address the outlined risks?
Let me take that. The guidance is giving a number of risk mitigants, a number of steps that actually countries can go into in order to mitigate, to address, should I say, the risks of P2P transactions. And it starts from the very general guidance with 3 points to say that the 3 sort of pillars and key elements to look at peer-to-peer transfers for the countries would be, first of all, outreach to private sector. So have an open communication channel to understand the risks, to understand the implications. Then they talk about the training of the supervisors, raising the awareness of law enforcement agencies on what those peer-to-peer transfers involve, how they function, basically to understand before making decisions. That's the way I read it. And the third point is the one which obviously I'm particularly happy about and not surprised about, again, is FATF is encouraging the countries, stating that the countries may encourage development of technology that would address peer-to-peer transfers, pointing out specifically blockchain analytics as an example. So these are the 3 aspects that the guidance is mentioning for countries to look at. And then it goes into more details and it lists a number of more, say, granular steps that countries should take, from very, very radical steps, such as prohibiting virtual asset service providers to accept or send transfers to unhosted wallets, through more, let's say, expected approaches with regards to the traditional AML application, traditional AML measures applications to crypto. For example, asking virtual asset service providers providing transfers to unhosted wallets to apply additional enhanced due diligence measures on such transactions, or making sure that VASPs that do provide such services are subject to a little bit enhanced monitoring on the regulatory side. So there's different ways. One of the interesting ways that FATF is suggesting countries to consider is to introduce some more granular controls that would allow them to understand the scale and the risks of unhosted wallets transactions. And an example given there is the introduction of reporting regimes, similar to reporting regimes in some countries where transactions above certain thresholds must be reported regardless of the risks identified. So there's different ways to address that, and it is yet to be seen in the industry what different countries will do. There's sort of a domino effect, though, in terms of the country's reaction. Say, for example, the most extreme step as prohibiting virtual asset service providers from transacting with unhosted wallets. If one country decides to do that, I can completely imagine the repetition of jurisdictional arbitrage and other VASPs going to different jurisdictions. And so there's more than ever the need for international cooperation on that point, I believe.
Anything else on P2P transactions? Barbara covered it pretty well.
I was going to say, I've got nothing to add to that. It's great.
Thank you.
Just mention one thing, though, again, on the peer-to-peer transactions. Peer-to-peer transactions to unhosted wallets, should I say, transactions to unhosted wallets may be subject to enhanced due diligence measures. And FATF is then stating in another fragment in the document that one of the enhanced due diligence measures is the use of blockchain analytics. So again, the use of technology is mentioned there, and the benefits of the technology that it brings.
Yeah, I can see it's kind of started a bit of a discussion in the Q&A. So there's a distinction between a provider of an unhosted wallet or someone who is sending money to an unhosted wallet who is a VASP within scope. Those people are always going to, the service provider, effectively the provider of the transfer, is going to be within scope of this new guidance. The wallet itself, the technology, is not on this current thing itself required to provide, because that's an individual or a business or a person. So this whole guidance is aimed at the service providers, the people who facilitate the transactions taking place. There's an interesting question about technology providers, and that's kind of partly addressed in the FATF guidance, particularly in the context of DeFi. It mentions technology providers of unhosted wallets. That's a little bit of a grey area, but wallet itself out of scope, a professional person who facilitates the transaction as part of their business is within scope. And then there's this grey area around technology providers. That's probably the easiest way to define what's a very complicated area.
And I'd perhaps like to check up the question as well on what I've just said in terms of prohibiting transfers to non-custodial wallets. I'm not aware of a direct initiative by any country so far on that point. However, there's, let's say, indirect ways of achieving that. And if you think about travel rule and the way it's planned to be implemented in some places, the implications of the travel rule in implementation may mean that effectively VASPs will be transferring only to other VASPs. So in other words, for example, the EU proposal for the transfer wire regulation for the travel rule implementation requires that the transfers to unhosted wallets are subject to the same level of due diligence, as in you need to, as a VASP, know who you're sending the assets to. Obviously, that poses a lot of questions to address in terms of unhosted wallets. Is it enough if your client provides you with the name of the owner or controller of that wallet? If not, how do you verify that they actually control that wallet? is that sufficient to confirm? And my concern would be that effectively, with those regulations taking that shape, some of the VASPs may take the decision, well, actually, I'm not able to feel comfortable that I'm meeting that requirement, so I would rather just allow transfers either only to hosted wallets or unhosted wallets owned by my customers, where I have measures to actually verify that this is their wallet.
Yeah, and on that point, moving into the kind of VASP due diligence, and I want to speak a little bit about the fifth area, the travel rule, which is hot conversation in the crypto space right now. So for those newer to this space, can you guys help us understand what is the travel rule and the associated sunrise issue?
So why don't I take this one? And this is something of my this is my personal interest area. So if I go on too much, you'll tell me to stop. So I just want to give a little bit of context. Again, I'm all about the context. The travel rule is not a new requirement. It has existed from FATF since the mid-1990s. It requires businesses within scope, and we've just talked about what that means in the crypto world, to share with each other, identifying information about the sender on the one side and the recipient on the other for transactions that they process, where the transaction value individually or in aggregate is over, in this case, $1,000 US or 1,000 euros. So if you have an individual who's making, comparatively small value payments below the limit, but they add up quickly to $1,000, it's still within scope. So a couple of important points. It's not new. It's existed since the 1990s. It was drafted with more traditional finance transfers in mind. So the extension of the travel rule to VASPs does have some elements of square peg, round hole. We can come on and talk about that. I don't know how well that translates, but it's not a perfect fit, that's for certain. But what I will say, and I am old enough to remember this, the discussions that the crypto industry are having now are pretty much exactly the same discussions that foreign exchange businesses, money service businesses, wire transfer services like Western Union had when the travel rule was extended to them. It's too onerous, our systems aren't set up for that. You've got this levels of compliance and obligation varying around the world. All of that was exactly the same issue that the wire transfer businesses had to and did engage with. So I think my first point is, this is a big issue. I don't underplay the complexity, and we'll come on and talk about that. But I think it is a comparatively short-term issue for the industry. We are already seeing some really good technical solutions coming through. We're seeing standards coming through. So I think my overarching message, particularly if you're someone who is like looking at this and thinking, how on earth am I going to deal with this? My message to you is this too will pass. Having said that, I think there are some features, particularly of the crypto industry, that are not as fully understood or appreciated in the context of the travel rule being extended. The crypto industry, by comparison with a more traditional financial industry, is nascent, it's young, it's moving incredibly fast. It has, frankly, less resources, although I know there are big players who have lots of resources, but overall, these are comparatively small players with comparatively limited resources who are trying to deal with a lot of issues at the same time. And there's much less clear guidance from regulators. So I absolutely think it is fair for the crypto industry to say, as they have been, that they need support for this transition. And frankly, more support than they are getting from some regulatory quarters. The second piece of context I want to give is why the travel rule exists. So the travel rule obviously helps with money laundering, terrorist financing. It stops payments to sanctioned individuals. It enables law enforcement to subpoena transaction details. We shouldn't get that. It supports reporting of suspicious activities, and it prevents money laundering. Now, my personal focus in my practice is a lot around money laundering and sanctions, and you cannot ignore the facts. For anyone who thinks that money laundering is all about guys in, dark car parks in ill-fitting leather jackets with £50 notes, I'm not saying they don't exist, but the money laundering industry is, it's a professional service industry. So big criminal gangs do not launder their own money. There are professional services, money laundering firms that are full of bright technical people. They have MBAs. If you're Iran, North Korea, or Venezuela, you've been doing this for years already, and you're using significant state resources. So as the rules for money laundering have tightened around the world, those highly professional money laundering service providers go to the points of weakness. And there are plenty. There's private credit, there's real estate, there's fintech, and there's crypto. So you cannot be naive about the fact that there is money flowing through the infrastructure and system that is criminal money. It finances terrorism around the world. You know, one of my personal professional sort of dealings is with human trafficking. It's absolutely astonishing and horrific, the amount of money that is being made off human capital in horrible situations all around the world. So we're all business focused, but you can't be naive as a provider. Yes, it is a small part of the crypto world and the crypto transactions, but it's growing significantly. And that is why FATF has taken this step and why regulators are so focused on it. So I think that context is important, because when we're dealing with this stuff, it's very easy to get your head down and just look at it as a rule. But there's context here that's really important. Businesses that want to have a long-term success will need to engage with this, not only because they need to, but frankly, because it's the right thing to do. So in terms of kind of where we are at the moment, there are some countries that have enacted regulations to enforce the travel rule, so require this exchange of information. There are a number of countries that are in the process of doing that, and there are plenty that haven't got around to it. Even within that group, there are different approaches. So if you're Singapore, you make compliance with the travel rule a requirement of licensing. If you're the UK, you effectively look for technical solutions, reporting obligations, and you bring it within that existing infrastructure. So this has kind of led to a lot of discussion around what's called the sunrise issue. So it's where each country implements the travel rule months, possibly years apart. You know, countries have different ways of doing that. What you effectively have is an industry in transition, and not everyone is in the same place. And that does a couple of things. It makes it more difficult to find technical solutions that work across your entire business. It creates more disruption within your own business. And it potentially drives business to the less regulated parts. So for those people who are in highly regulated jurisdictions or who want to build their business within this infrastructure, there is a kind of business imperative as well. I have lots more to say about the travel rule, but I'm happy to hand it over to someone else to comment.
Yeah, no, it's a tricky one. I guess we'll have, Barbara, did you have something?
I was just gonna say, in terms of the travel rule, again, there's more clarity in the guidance, and I think that one is actually pretty clear in comparison to others. There's a very detailed kind of information as to what details have to be collected on the beneficiary, what details have to be collected on the originator. We didn't have that in the previous document. I think I found it very useful, and that's what I'm hearing in the industry as well. There's one point which is fairly small, but it does raise my eyebrows, and we've relayed that in various industry discussions as well. There's a requirement to sanction screen the name of the beneficiary or the originator, which completely makes sense. It's absolutely justified. However, I think there's a little bit difference in terms of the level of information that VASPs will have to handle those hits in comparison to banks. Because if you think about it, the banks, if they screen the name of the beneficiary, and that beneficiary is verified on the other side in a bank that the transfer is made to. In terms of the crypto assets industry, obviously we've got that issue of transfers to unhosted wallets, where I as a VASP need to collect the name of the controller, of the owner of unhosted wallet, and screen it. And then if you don't have KYC information on that wallet provider, on that wallet owner, which you may not have because they're not your client, imagine handling the screening hits on, I don't know, say John Smith or other popular names. So it's a very, very tiny thing, but I'm curious to see how that will play out operationally.
Yeah, and interestingly, again, I don't mean to keep going back to it, but exactly that issue came up in the context of the wire services people in kind of, I think, about 2005. So again, I suspect there will be industry solutions, and we've obviously always seen OFAC actually list wallets on their sanctions list, which is quite interesting, right? And we may see more developments like that. It's one place, it's one specific issue where being in the EU or within the scope of the EU rules that have that did not know, had no reasonable cause to suspect, defense built into the sanctions piece is actually quite helpful. But yeah, I completely agree. It's a challenge whenever you take traditional financial concepts and architecture and try and kind of shoehorn them into an emerging industry that works on a different basis. Again, I think I'm relatively confident that over time things will shake out, but that's no help to people who are dealing with it at the moment. And I do think we're seeing a range of it. It's the thing I'm advising on most at the moment. And I think we're seeing a range of approaches. So lots of technical solutions, lots of standards coming out, but they don't necessarily interoperate, which is a massive issue if you have a lot of different business lines. I think whitelisting is something that I'm seeing a lot of people doing, and that has a lot of easy solutions to it. Oh, I'll whitelist this exchange. It doesn't totally manage your risk. And how do you monitor that on an ongoing basis? I have yet to see anyone who whitelists a fellow exchange and says, but I want reporting data so I can kind of test that for myself. And I think that's where probably regulators who say, okay, you can whitelist, but you have to keep on top of that and ongoing monitoring. I suspect that's where they're going to go with those types of issues. So it's really interesting. And I think it's the lack of clear sort of solutions for the industry that everyone can get behind. That will come, but it will take time.
Yeah, it's definitely messy with a lot of friction, but hopefully, like you say, it'll smooth out. So I want to shift gears and talk about practically implementing this guidance, because we have a lot of entrepreneurs and leaders of organizations in the room who are thinking about this for their own companies. But at first I want to start with the opposite. And I know, Harriet, you touched on this a little bit at the beginning, but what are the implications of not adhering to the FATF guidance?
I mean, so the FATF guidance applies to countries. So it's going to very much depend whether you're in a country that has implemented guidance in response to this or not. So if you're in a country that has implemented rules to update their guidance and you don't comply with it, you have some obvious risks. Prosecution, enforcement, loss of license is probably the three biggest ones. Even if you're in a jurisdiction that has not yet implemented the updated guidance, there are some reasons you might want to start looking at this. And that is because you will find it will limit your ability to do business for people who are in those jurisdictions than it has. And I think more practically, I mean, look, no one on this call needs me to tell them the difficulties that crypto firms are having getting access to traditional banking and financial services. If you are in a jurisdiction and you're not dealing with this, it's going to make it harder for you to access those types of traditional financial services and banking accounts. So I think there are some good reasons to look at it, even if you're not. Josh, I don't know from the US side, because you have an expansive view in the US about what's in your purview.
Well, when you have the world's fiat currency for now, you tend to act that way as a government. Not to be glib, that's what people think here. So I'm just putting it out there. I think that as a young lawyer, I was involved in sort of the first Treasury Department action against a bank following the adoption of the Patriot Act. It was against a small bank called Riggs Bank, which is no more with us. And I learned then, and that was in 2002, 2003, and it's true now, that the anti-money laundering laws in this country are severe. And those and sanctions are increasingly a tool of political or intergovernmental policy that our country uses against others. So it is taken very seriously by law enforcement as well as financial services regulators in this country. And so there have been proposals made around digital assets by the Office of the Comptroller of the Currency in the Treasury Department. Now, those were made in October of 2020, last I checked. And we've had since an election with a change in the leadership at the OCC. And so getting things tailored specifically by rule to digital assets in this country will still take some time. I sort of feel like the first year of the Biden administration has been spent ramping up, getting people in place and figuring out the priorities. And so we may see more action now. But I really think you can't sit around with your funding or your business ideas to see what people here in Washington, D.C., which is not business-oriented, no matter who's in power, are going to decide for you. And so saying that, we have a lot of conversations, Harriet and I do, and others here at the firm, with people looking to either push out services and products in the digital asset space from a business organization in the United States to other countries, or they're outside the United States and they want to, or they fully expect that not only will they have users in this country, but they want to have operations here. Crypto mining in particular is something we're focusing a lot on in the last couple months. And so I think the guidance gets at this. It's sort of not only where are you organized and operating, do you have money laundering risk, but where do you sort of then go on to do business in a different jurisdiction, what are the requirements there, and that's where you get the tension. So I think the FATF recommendations are a good starting point for understanding what all the regulators who participate are trying to get at. But really it does come down to, first and foremost, where are you, physically, if I can still say that, conducting operations, would you say, in the case of a VASP, and then where are the likely jurisdictions where you think you're going to be doing business and you have to worry about that. And it is not easy and it's not difficult, and unfortunately that's where some of that funding goes to deal with issues like this, so you don't get shut down as one large and well-known exchange has faced that threat lately precisely because of failures for anti-money laundering compliance. And that was civil enforcement action as well as still pending criminal action against the principals there. So that's a lot, but there's quite a lot to do, I'm afraid.
Certainly agree on what has been said. Just want to add one more thing that we already are seeing in the private sector in our business, which may not be that obvious, but non-compliance may actually also result in the loss of the opportunity for investment. And let me explain. We're working with some of the asset managers who are looking into investing DeFi. It's obviously a hot topic and a popular investment to consider at the moment. And what we're providing them with is our unique product of liquidity pool reports, where we scan the interactions of the smart contract with different addresses, and we basically risk profile the DeFi liquidity pools, the DeFi assets. And those asset managers actually are taking their investment decisions based by, well, among other factors, obviously, based also on the money laundering risks of such a DeFi platform. So if as a DeFi platform, you're not ready yet to introduce any AML controls, such as our AML Oracle at CoinFirm, you may be risking actually losing the opportunity to be invested in.
So there's certainly a lot at stake here. So best to comply. And I know the guidance, just following on that, Barbara, I know the guidance touches on tools. So what does it say about blockchain analytics and how it supports in conducting risk assessments?
Yeah, it does say quite a lot, actually. Again, didn't come to me as a surprise. We at CoinFirm are very open to cooperation with FATF, and we were one of the blockchain analytics companies included in the statistics that were provided to FATF to be looking into their guidance for peer-to-peer transactions. So that was published, I think, back in July. But I think FATF and more increasingly the regulators are more and more aware of the capabilities that blockchain analytics can provide, obviously if applied correctly and with the right set of data. So in terms of the paper, if you do Control F and search for blockchain analytics, it comes up really in different places. The main ones that I would mention that I can find in the paper are, first of all, as one of the tools to address peer-to-peer transactions risks. So linking to something that I said before, transactions from VASP to unhosted wallets may be subject to EDD measures. Blockchain analytics may help you with EDD measures. Then they do mention blockchain analytics as one of the tools, one of the mitigants rather, being increasingly applied by and looked into by supervisory authorities, by the regulators. And without it to go in the details, without disclosing things that we should not disclose from business perspective, we do see that also in terms of our business and in terms of where that interest is going. And last but not least, there is also a mention of blockchain analytics as one of the tools helping VASPs and financial institutions to monitor their own risk exposure. So basically using different tools and reports that Coin Firm also provide in terms of understanding, okay, as a VASP, what is my exposure to transactions from darkened market? What is my exposure to transactions from ransomware or touching upon ransomware? And that's exactly the type of analysis we do for DeFi. Liquidity pools and for DeFi space, and that can also be done for protocols, for VASPs, for really any type of like pool of addresses, and not a surprise that FATF is mentioning there as one of the measures, as it does provide great insights into controlling your compliance and also making compliance decisions.
Great, thank you. So there are so many eager stakeholders in the room, which I love. So let's break and then jump into some of their questions in the Q&A. I want to go back to one that was towards the beginning. So Jakob has asked, which country has developed the most legislation in crypto while still allowing the development of the industry? I think that was the gist.
Look, I mean, there are a number of jurisdictions that have set out clearly defined structures for development of a lightly regulated blockchain industry, rather than saying we'll simply provide our existing structures. So there's Gibraltar, there's Estonia, there are a few out there. There are sort of pros and cons for each of those, and one of the things that I think is quite interesting is once you put that into legislation, no matter how broadly you draft it, the technology still moves beyond it. So I think when I look at some of those legislative proposals that are even now only kind of like 2 or 3 years old, they look a little dated for where the industry is. I think there are any number of different approaches that regulators can take to this question of how to regulate. Do you do something that's specific for crypto? Do you do a sort of light touch version of your existing regulation? Do you do nothing unless it clearly crosses over your existing boundaries? All of them have pros and cons. This is just my personal view as a lawyer. I think the most important thing is that you're in a jurisdiction that other people will be happy to do business with. And again, that is changing all the time. So this is slightly off topic, but FATF also do a list of high-risk jurisdictions, and they do that by assessing on a regular basis different countries' money laundering rules. So if you go onto that high-risk list, it has all kinds of consequences for the ability of people in that country to do business. You get subject to EDD. As countries come off and go on that list, it has a massive impact. And there are certainly countries on that list now that were not on that list, offshore centers 2 or 3 years ago. And so all the people who've set crypto businesses or funds or even financial institutions who now find themselves in a jurisdiction what's on that grey list are having massive issues. So it's one area where actually going somewhere that's lightly regulated may not be the best long-term solution. So you have to balance short-term gain versus long-term pain.
Okay, let's go into another one. Thank you, Harriet. So somebody has asked, what guidelines might the FATF consider for metaverse type platforms to prevent money laundering? Any thoughts there?
I would simply say, let's wait and see. I think, all the things we're looking at, the metaverse is the most nascent. I mean, we are sort of seeing this arc of people that want to do some form of token, connect that to a DAO, and then get into the metaverse with a specific product or service represented on the blockchain. So I think getting up to the point of getting into the blockchain, through a distributed ledger, there are a lot of points where the FATF guidance will intersect based on whatever country you're in. But in terms of the metaverse itself, if I'm in there interacting with someone else and virtually buying a good and service, I would think that FATF is probably a far cry from dealing with that, as I think many regulators are. So I would just simply say, wait and see on that, because it's not only are the regulators, I think, very far away from touching on that, and I may be proven wrong about that. I think that you sort of see right now, when people talk about the metaverse, at least in traditional publications, they're sort of linking it to metaverse concepts put out there by companies that are already, for example, public companies in the United States, Facebook, Apple, and their conceptions of a metaverse. So we don't really even have a good concept of what that is yet. So I think we should wait and see.
Yeah, I would completely agree. There are any number of interesting, geeky legal issues that will have to play out in the context of the metaverse, and money laundering is in them, but it's probably not near the top in my view. It's kind of like if you were, and again, I'm old, so forgive me, when the kind of like the internet sales industry was nascent, and we had to go through all these things about distance selling and what rules applied, all of that will have to be worked out in the context of the metaverse. And there will be people who kind of make an early stake on how those transactions should be done, and where we end up may be somewhere quite different. So it's an issue, but it's probably at the bottom of quite a long list, I would say.
No, definitely, but still very fun to think about, and maybe one of the topics for a future webinar. So I want to jump back to the guidance. So we're 3 months in, or maybe just over. Are you noticing a shift in how your clients are thinking about or taking action following the publication of the guidance, updated guidance?
I mean, maybe you go first. No, you go first, Josh.
All right. I would say, working, not surprisingly, being in DC, most of my time is spent working with clients in the United States. And there, and even with some of our international clients outside the United States, I think that plans are still considering, or plans that are under consideration are still going as planned. But what I do think is you're sort of hearing money laundering come more into the discussion, where it wouldn't have been amongst the top 5 points you're talking about, say, in the design and architecture of a product or service on the blockchain. But I think it's quickly come up, and it's come up beyond the level of, are we a money service business or not, to sort of, to use the US definition of something where you would have to have a license and have AML requirements. It's sort of come up with, what are my risks as a recipient of funds? What are the risks that could apply to me? So sort of whiteboarding it a little bit, as opposed to sort of saying, oh, FATF has done this, now what must we do? It more as a general awareness, which I think is kind of how this is all supposed to work, until you're down to something very specific. That was at least my limited experience working with international bodies like IOSCO and so forth when I was in government.
Yeah, I would just say, like everything in the crypto industry, it moves very quickly, and everyone turns kind of, we'd say, on a dime. So everyone knew this was coming 6 months ago, 5-6 months ago. Everyone started to really focus on it when the first rules started coming in, and I'm thinking particularly of Singapore. Singapore implementing the travel had a massive impact because there were big players who are regulating that, and they then started trying to push that out to their counterparties because Singapore's gone down a particular route. So the last quarter, it has been the big issue that I think we've talked about. Everyone's still trying to work out how to do it, and I think Barbara will have probably some quite interesting insight about the kind of practical and technical piece, because that frankly is where the work needs to be done.
And it's actually a quite positive trend we're seeing. We're more and more exchanges, VASPs coming up to us, even if they're located and registered in jurisdictions that do not have AML requirements for VASPs yet. And there is an increased interest, and I would say awareness of the fact that the regulations are coming even if they're not in your jurisdiction. So that's a quite positive trend to see, of the industry being proactively approaching that and making sure that they do have tools and controls in place before the required regulation is effective in their jurisdiction. So that's certainly a positive side of things that we're seeing. The other area that I'm seeing as sort of a trend as well is still uncertainty with regards to DeFi sector. And I think I saw in the Q&A a question about DAOs. That's certainly, at least from my perspective, the biggest question mark still as to how that VASP definition would apply to DAO. And I think the same question is being considered and looked into by the regulators at the moment. So there's no clear yes or no answer to that point yet, I suppose. And again, I would stress out that the cooperation between private and public sector is needed. And I'm saying that from both sides, from private sector to be proactively thinking as well, how to approach that to DAO. Say if we had voting for, say, Taproot in Bitcoin, could we do the same type of controls in DAO that would allow us to introduce some sort of compliance framework? On the other hand, the regulators and the lawmakers, the cooperation there that I would expect is kind of going outside of that box and stepping out from the traditional thinking and being open to talking to developers as well to see what are the technological solutions, and hopefully also making sure that within the regulators there is staff that has some technical understanding, because unfortunately or fortunately, because it's hugely interesting, I think to make right decisions you do need some technical, at least foundation, to understand how those platforms work.
Absolutely. So we have just a few minutes left, so we could definitely go on for hours. It's really an interesting time, as many crypto platforms were, not necessarily designed to work alongside compliance requirements, as you might see in other sectors. And then you have many non-crypto companies putting digital assets on their radar or even on their product roadmaps for the first time, and just trying to comprehend what that means. So it's complicated and a very quickly evolving space. And I'm sure we'll have, a follow-up discussion on this in a short while. But I want to thank again all of the panelists for your time and for the discussion today, and for everyone in the audience for tuning in. Hopefully you learned something new. You have a few nuggets to take back to your colleagues. We'll also be sending a recording of the webinar. I know somebody had asked that. And also our 13 FAQs to the updated guidance as a small token of appreciation for your joining. So please let us know if there's any way we can be helpful to you in your next steps by emailing us at contact@coinfirm.com, and have a great rest of the day and a wonderful 2022. Thank you.
Thanks, everyone.
Yep, bye-bye.
Bye.